Greeting, friends. I'd like to take this opportunity to go over explaining the SPC or Secured Party Creditor process, because sometimes people have questions, sometimes people feel that it's overwhelming, etc., etc., etc. So let me just do a service here of breaking it down and just explaining to you, because to me it sounds very simple. To me it is very simple, and people miss the simplicity of what it is. If you can't explain what the secured party creditor process is in a sentence, or 5 or 6 or 7 words or less, then in my opinion you are overcomplicating it. So let's try to define it in 5, 6, 7, or 8 words or less, or at least 1 sentence or less, and then you can marinate on that, or you can sit on that, or you can process that, and you can walk away understanding how simple it is and have a lot of confidence in understanding what you are doing. Because a lot of people, they even sign up and become clients of mine, and then they don't understand what they just did. And so, we don't want that. We want people to fully understand what they do before they become a client. So, and that's not to say that they have to become an expert on everything, but just to understand exactly what it is that you're doing is important to me before you jump in and do it. So, the bottom line is this, and then I'm going to read some supporting material and some further explanation. But the bottom line is this: your name in capital letters is a trust that was created with your birth certificate. So it is a trust. Another name we can call it is your legal name. Okay, so when we talk about your legal name, we're talking about the name on your birth certificate, or whatever it was changed into is another modification of it. It's the same entity. It's like if a corporation changed its name, it's still the same corporation. It has the same buildings, it has the same property, it has the same balance sheets, tax returns, board of directors, owners, CEO, president, employees. It's all the same. Nothing changed other than the name that it wants to call itself and be recognized by. So if you've had a name change, it's immaterial. It's the modified or amended name, but we're talking about the same entity. Okay? Talking about the same entity. And it is not a corporation. It is a trust. There are differences between corporations and trusts. There are similarities between corporations and trusts. Okay? So a trust is basically a entity set up by someone, put in control by the next party for the benefit of a third party. So party A sets it up, party B is given the authority by party A to control the entity for the benefit of party C. Now, some of these parties can overlap. In other words, party A can also be party B in some instances. Party B can also be one of party C's if there's multiple party C's, and party A can also be party C. So that goes into, you can look into all that, but that's basically it. It doesn't have to be incorporated. It doesn't have to be written in writing. When you write all the terms and conditions, it's expressing it in reducing it to writing, and therefore it's called an express trust. When you don't write out and write declaration of trust and write out all the terms and conditions on many pages, it's not an express trust. It's either a constructive trust or an implied trust. So you can Google those terms. What is a constructive trust? What is an implied trust? I know we're getting into a lot of detail here, and I kind of said that we were just going to keep it simple. So just to backtrack and keep it very simple, you can research these terms further, but just to keep it very simple, your legal name is, for most people who don't run corporations and who don't run other trusts and who don't run other entities, you're not a CEO of a big Fortune 500 company. You're not the owner of a startup company, an internet company like Mark Zuckerberg is the CEO of Facebook. You don't run any other companies. Now some of you do, and we'll talk about that in a minute. But for most people, they don't run any other companies. But they do in a sense kind of run their all capital letters legal name or birth certificate name or trust name. All mean the same thing, okay? So here's the thing though. You think that you run it, however the government comes in and regulates you and tells you what to do and taxes you and fines you and then tries to control you and your property and the way that you run it and tells you how you can run it and so forth. So you're not really running it. So in a trust, the legal title is, or in a trust, the controller, right? So in a corporation, like the one who controls things is kind of like the CEO, but they're appointed by, and there's a checks and balances in a corporation. The CEO is running things on a day-to-day basis, but they are elected by the board of directors and governed by the board of directors. So they can be terminated and fired by the board of directors. Now, if 51% of the representation on the board of directors is owned or controlled by the CEO anyway, then the CEO is said to have a controlling ownership 51% or more, or 50.1% or more, and then obviously if they represent 51% of the shares of the company and there's a vote on firing the CEO, obviously whatever they say goes, because all the other shareholders can only accumulate 49% of the vote, and if the CEO has 51%, then they're going to outvote them, so they're never going to fire themselves. So you see this in lots of instances all the time. So anyways, back to trusts. In a trust, it's different. In a trust, there are no shareholders that get to dictate the firing of the CEO or anything like that. In a trust, the grantor appoints the trustee, and in an irrevocable trust that can never be reversed. So the grantor is out of the picture, and the trustee is there to control. Or there might be more than one trustees. Okay? So the board of trustees, and if it's just one person, then you're the only person on the board of trustees. But the board of trustees controls, and no one is having a board meeting and checking on them and regulating them and firing them. However, they work for the beneficiaries, and the owners or the shareholders are the beneficiaries. They are the ones that at the end of the day, when all the profits are made and then there's a distribution to the owners, which could be very finite. It could happen once every 10 years. It could never happen. It could happen at the dissolution of the trust, when the trust is dissolved. If the purpose of the trust is to exist for 25 years and there's no, motions and agreements made to extend the life of the trust and keep going for another 25 years, then that's it. When the trust is over, that's it. You collapse the trust and you pay out everything to the beneficiaries or the shareholders, or you extend it for another 25 years. Or it could be, some instances, perpetual, but you can look into that. There's a lot of reasons why you can't have it say perpetual on certain types of trusts. Blah, 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 blah. This gets into trust law and court cases and how the law has molded over the course of time with the application of trust in practice. Okay? But anyways, back to this. So the trustee is in control, and I said and they're working for the beneficiaries, but the beneficiaries do not have control. They cannot have a shareholder meeting and tell the trustee what to do. Okay? However, there's some gray area. In some instances, they may be able to have rights to monitor, review the balance sheet, get a statement of how well the trust is doing and how much monies or benefits they're entitled to. In some instances, it's not. How do you know what rights the beneficiaries have? It's all determined by whatever is put in the declaration of trust by the person who created the trust, which is the grantor. So the grantor and the trustee have a contract. Okay, by the way, another word for grantor is creator, settlor, or trustor. So if you see those terms, trustor, settlor, creator, grantor, they're all synonymous. They all mean the same thing. So when you're reading about trusts, you might see the word trustor. The trustor with OR at the end, trustor, creates the trust, puts the control in the hands of the trustee, Trustee. Okay, so those terms are different, and make sure that you try to notice that they're different. To make the clear distinction, I always use grantor and trustee when I'm explaining it, not trustor and trustee and things like that. But you can use whatever, the terms are synonymous. So anyways, the bottom line is that your legal name, the name that you've been using that's on all your documents, bank accounts, driver's licenses, applications, everything that you've been doing your whole life, okay? Now let me ask you, it's what you've been doing in commerce, what you've been doing in contracting with the United States Corporation, what you've been doing to receive any currency, whether it be in US dollar, funds, or whether it be in another denomination of currency. Everything you've been doing and every title to property that you've been having has been in your legal name, your legal trust name. Now, you might say, well, what's the difference between me and my legal name and any other name? Well, you might respond to other names. You might have a significant other, domestic partner, comrade, lover, housemate, whatever. You might have somebody that calls you sweetie, right? You might have somebody that calls you honey. You might have kids that call you Poppy. You might have your lover that calls you Poppy. You might have people in your life. You have a dog that might call you woof, woof, woof. You might have people in your life that call you a variety of different things. They could even call you, if your legal birth name says John Smith on it, you might have friends that call you, Steve or Dominique or Chris or Christopher. But that might be just another nickname that you have, or another pen name, or a lot of people write books and or do things in the world, and actors, actresses use, in all types of situations, use other names, right? But that's not their legal name, okay? But especially in private, you probably have a lot of different names that you respond to, okay? But that's different than your legal birth name. When it comes to owning property and having funds and things like that, you need some entity. It doesn't have to be your legal birth name, but it has to be an expressed legal entity, right? That has documentation and things like that. It could be a corporation. Corporation doesn't have photo ID. Corporation is an entity. There are other formation documents to prove the veracity of that corporation, and that the deposits and of money, contracts, owning titles to property are all done with proper certifications, so to prevent fraud, so that people can't just go out there and say, oh, I'm so and so corporation, I'm going to buy this house on behalf of so and so corporation. Well, you have to prove that you're an authorized representative of that corporation, and you have to prove, you might have to prove that the board of directors made a resolution to allow you to make the purchase of that home on behalf of that corporation, or to sign a document giving a lien hold interest, or to deposit a certain amount of money into a bank account, or to open up a bank account for the corporation, and to be a signer on that bank account, and to have a debit card issued in the name and a checkbook issued in the name of the corporation, with you as an agent being able to use the ATM, deposit, withdraw, transfer money, etc., etc., etc. So, there's lots of ways that you can, operate in the world and deposit checks and sign contracts and do lots of different things, but most people in their quote personal, individual quote personal life, most people are only operating one trust, which is their legal name, to do all these things in. Now you can operate as many as you wish. You can operate as many trusts as you like, and you can operate as many corporations as you like. And what's the benefit of that? Well, the benefit of that is you can't rob Peter to pay Paul, right? So if there's a lawsuit against, so-and-so corporation or so-and-so LLC or so-and-so trust, well, they can't go after one of the other trusts or one of the other corporations that you might just so happen to be involved in if there's, liability that is incurred from one entity. You keep all the entities, separate. So that's why people form limited liability corporations. And on construction sites, every single builder, like a Donald Trump or these different, he has the Trump organization, or any construction company, okay, or, etc. They set up a brand new LLC usually, or corporation, usually it's an LLC, for every construction job. And when the construction job is done, the company is dissolved, and all the money is given to the owner, to the owners, and that's it. So the corporation is dissolved, it can't get any lawsuits. It can't get service of process of any lawsuits. It's over, it's done. So that's a very smart business move. Now, obviously you can't do that with your legal name trust unless you, well, actually you can do that with your legal name trust, but that's not the purpose of this recording. Most people are not going to want to do that with their legal name trust because they that's the most easy thing to contract with, that you already have identification and you already have all these different things going on with it. The bottom line with this is that the SPC process puts you as the trustee over your own trust instead of what you are or what you have been your whole life. What you have been your whole life was just a beneficiary. And what you have been your whole life, again, the beneficiary of a trust is not like a shareholder. And even if you were a shareholder and you were able to, vote, you're just one of many shareholders, right? If you own shares in Facebook stock, you have probably a less than 1%, right? And you've got hundreds of thousands of people that own Facebook stock. So you're going to go to the shareholder meeting, or you're going to appoint a proxy to go to the meeting and enter a vote for you. And if you want to go and, mandate that Mark Zuckerberg follow a certain protocol, or that he be fired entirely and replaced with someone else, well, it's not going to work because you own less than 1% of the voting shares. You need to get a 51% of the vote. So even if you were a beneficiary, then brings up the question, do you have 51% interest or more? But as I said, in a trust, it doesn't matter. If you have 100% beneficial ownership, you still can't tell the trustee what to do unless, well, actually, you can. You might have some ability to get information on a regular basis about how the trust is performing, but you can't control what the trustee does unless, now, beneficiary can sue a trustee if he accuses he or she or the entity, whatever, whoever the beneficiary is. Beneficiary can be another corporation, could be another LLC, could be another trust, right? So if you're a beneficiary or you represent an entity that is a beneficiary and you believe that the trustee is committing fraud, then you can do certain things. If you believe that they're stealing from your trust, then you can do certain things. If you believe that, or have right to believe or reason to believe that they are, committing fraud, usury, negligence, other wrongdoings, other torts, other wrongdoings, then you may be able to do things. You can initiate a lawsuit, and we can prove, go through a discovery process, go to trial, prove in a court that they are doing wrongdoing. And then therefore the court will probably order that they be removed as a trustee, blah, blah, blah. However, before you bring any lawsuit into court, you have to look at jurisdiction. What's the jurisdiction of the court? What's the jurisdiction of the trust and the court? Okay? For the first thing that needs to be established before you move forward is jurisdiction. And in every lawsuit, every complaint that you'll read, you can go up online and find ways to pull down lawsuits and, read them. Every lawsuit establishes jurisdiction in the first few paragraphs before it moves on forward and starts to lay out the facts, lay out the case, lay out the conclusion, the facts, conclusions of law, the accusations, and then, makes an accusation or makes a claim or shows, evidence of a claim, and then allows the other party the opportunity to answer and respond or to admit the facts, and then move forward for a conclusion in the lawsuit, which would be a judgment, right? So the jurisdiction is important. And when you review whether it's a civil case or whether it's a criminal case or whatever it is, okay, whether it's in statutory law based, common law based, now the plaintiff always has the right to decide the law form. So the plaintiff can always come and say, we're doing this under common law as per blah, 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 or we're doing this lawsuit under private international law, or we're doing this lawsuit under the laws of the corporate state of California. Okay, so the plaintiff always has a right to decide what law form, what jurisdiction this is moving under. Okay, but they also have the burden of proving jurisdiction. So when they file the case and they say, we have jurisdiction based on blah, 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 blah. Again, whether it's civil or whether it's criminal. And at any point in time, the defendant or the respondent that is responding to the lawsuit, trying to defend themselves, probably trying to get the case thrown out if they see any loopholes that they can get the case thrown out early on, perhaps. They look at jurisdiction, they say, we can get this thrown out because of jurisdiction. This court doesn't have jurisdiction. Okay, now subject matter jurisdiction, or just on a face jurisdiction, what the courts will look at jurisdiction a lot of times, and they'll ignore a lot of the other types of jurisdiction, like in personam jurisdiction, unless you specifically raise that you're challenging in personam jurisdiction, like in a criminal case and you're a sovereign and you're claiming in personam jurisdiction is not established. They're always going to say, oh, we have jurisdiction because the incident happened in this geographic location, and they're going to make you sound like, that's the only issue related to jurisdiction, and obviously it's not. You also have in rem jurisdiction, in personam jurisdiction, and subject matter jurisdiction. Okay, so territorial jurisdiction is a part of subject matter jurisdiction. Okay, so they're trying to say, well, we have territorial jurisdiction because of the geography. This happened here. It's just a way so that courts don't fight over each other. The federal government doesn't fight over the states, doesn't fight over the county, doesn't fight over the city as to who's going to proceed with the charge. Okay, and so that's part of what they focus on and what they talk about is, well, hey, this happened in the state of Texas, so we have jurisdiction, not the state of Oklahoma, and so they establish jurisdiction, or this happened in this county instead of the neighboring county, so we have jurisdiction, or these consumers or these respondents or these defendants live in so-and-so county, so this particular court has jurisdiction, and it's a civil monetary loss, a lawsuit for monetary compensation, monetary damages exceeding $25,000 or less than $25,000, or exceeding $10,000 or less than $10,000. They have small claims court, has jurisdiction over any matters, any local matters like that, less than either $5,000 or $10,000 or whatever it is, you got to look at the courts in the local area. It's different in different countries. And every state is its own country. You have 50 plus countries in the, there are 50 states or nation states in America. So, and then you have DC and you have Puerto Rico, Guam, all these different places. So there's actually more than 50 nation states. But all those countries, all those nation states, all those states have different criteria for, what court. You've got small claims courts, you've got circuit courts, superior courts, Supreme Court. You got different places, and they all kind of establish where they draw the lines of which court has jurisdiction over what types of matters. A lot of it has to do with the dollar amount being sued for if it's civil, but there's other situations as well. And then you got the federal government. You need to have, or not the federal government, but to go to federal court, you need to have specific type of jurisdiction, and that's the purpose of another audio. You can just go on Google right now and you can type in, what gives jurisdiction to open up a federal lawsuit. You can type something in like that or different variations of that, and you can find the answers, and you can do some reading and doing some research. Anyways, back to the trusts. So beneficiaries can't sue trustee unless there's some fraud or some negligence or something that is an exception to being held harmless from liability, because the trustee is usually going to be not, or even in a corporation, a CEO of a company is usually going to be not liable personally. You can't sue his personal all capital letters trust name. You can't sue Mark Zuckerberg if you think Facebook wronged you. You're supposed to sue Facebook directly, and there's only a couple of particular courts that you can do that in based on subject matter jurisdiction. But you can't sue Mark Zuckerberg directly unless he's committed fraud. And if you're a shareholder of Facebook, then that gives you additional potential rights to sue, whereas a consumer probably can't, has a less likelihood of suing the executives directly. But if you're a shareholder and there's something that they're doing that's wrong, then you have an additional possibility of ways that you can sue the trustee or the CEO in a corporation personally. So I think this gives a little more context to trusts and the different players involved. But the bottom line is, right now, most people that have a birth certificate and have a legal name are not the trustees of their own all capital letters named trust. You are only a beneficiary right now, and you're not the only beneficiary. Okay, the state of wherever you live, the state of Texas is one of the beneficiaries as well. Don't they get state income tax? Or maybe Texas doesn't have a state income tax. I don't know, but there's like 6 states that don't have state income taxes, like Florida, Wyoming. There's a bunch of others. You can look it up. So, let's just say California. That's the easy one. If you live in California, California charges a pretty high state income tax. I think it's like 10% for most people that earn a certain income. New York too as well. So, not only do you pay federal income tax, you pay state income tax. So the state is a beneficiary of your legal name trust, because at some point over the course of the year or of your life, from this all capital letters trust operating, the state of California or the state of New York is getting some money. And they're also getting money from your activity. Even if you didn't owe any state income taxes, there's lots of other things that go on. Okay, there's excise taxes put on fuel at the pump, at the gas pump. So if you use gasoline to pump up your car or fuel to heat your home, there are taxes that are put on these things, and they go to the state as well. And the state also provides services as far as highways and maintenance of highways and things like that. So then there's another trust within a trust, and they're actually benefiting, millions of people who use the roads. So those would be beneficiaries of the state of California trust. or state of California corporation, and there would be, potentially millions of unnamed beneficiaries of that situation, of the state hiring people to fix up the roads. Okay, but there's also people, administrators, and people that work full-time for the state of California, and they get a salary and bonuses and all sorts of different things. The governor, I don't know how much the governor of California makes in a year, but his whole salary is paid for by the taxpayers. Okay, same thing with the president of the federal government, the United States of America. Okay, so there's lots of beneficiaries to that thing running, but there's also lots of executives that get a salary and get a cut. So those people are like the trustees, the people involved in this public trust that everybody benefits from the roads being, the potholes being fixed in the roads, but there are trustees who get a cut of running and managing and administering this thing called the state of California. But it's the same thing for your legal name. Your legal name is not much different. You're just a beneficiary. You get to ride on the road that doesn't have the pothole, so to speak, in your own situation. So what do? They take taxes for this, that, and the other thing, fines, fees, regulations. You want to own something. Every time you make a purchase, you have to pay a sales tax. You have to pay a title transfer tax. Boats, homes, auto, everything. Okay, and even currency. Every time you own or become the new owner of currency, you have to pay a tax. That's called an income tax. Okay, so you are just a beneficiary of your all capital letters legal name trust. And how do we know that? Because if you were the true trustee, you would be the only controller dictating what goes on related to your legal name trust. You'd be the only, executive. Or if there were other trustees, then you would be in communication with them and have board meetings and have to come to a vote or come to a consensus. That doesn't happen. So what happens? What is happening? What's going on with your legal name trust? Right? They are the legal title holders of everything. This is why when you register an automobile, they have the MSO, the manufacturer's statement of origin, which is the legal title. You're registering everything to them. You're getting permission. You're putting in applications. And the trustee looks at it and they say, okay, beneficiary wants something, puts in an application. All right, we have a duty and obligation to perform and give the beneficiary what he asked for, but we're going to take our cut and we're going to regulate it and we're going to tax him and we're going to send building inspectors out and we're going to have him pulled over the side of the road every time, every so often, or give local police, traffic police authority to pull you over and check that your tires are inflated and check that you're wearing your seatbelt and ask for your license and registration, ask you all sorts of other questions and give you fines and tickets and make you appear in court. So they're dictating how you use the benefits that they're giving you. They own everything related to this trust, but then they're giving back like 75% of it to you, and they're saying, we're going to take our cut with all these taxes and keep the other 25%, or whatever those numbers are, and we're going to also regulate how you use it. We're going to infringe on your privacy and just come and do whatever we want. And we can also change how we regulate you using the benefits of your stuff, of the stuff of the trust. So you see how you're never really the full, controller of any of your property, including money, including property, including your offspring, including your kids. Okay? The government only leases to you, right, the capacity to use your kids, your money, your bank accounts. This is why they can freeze your bank account at any time they want on suspicion without, proving you did anything wrong in a court of law, because they're the trustees, they're the administrators, and they can pull you into court anytime that they want to. So Are you starting to see how the government is the trustees and you are just a beneficiary of your all caps legal name trust? Okay, so this is a situation that people are trying to get away from. People are trying to become sovereign. So the way that we do that is with the secured party creditor process. Among many things that we're doing with that process, just in a simple way, the bottom line, and in the beginning I said that we could narrow this down into like 5 or 6 or 7 or 8 words or less. Let's see if we can do that here. I would say that this process is you reorganizing, keyword, reorganizing your existing legal name trust. That's it. I think that's 6 or 7 words or less. Reorganizing. And why is it reorganizing? Because you're not creating, and it's, you know, this is just kind of a maybe something that was looked over, but I have a lot of clients that's, you know, sometimes they're doing this and it's overwhelming and they're asking, why are we creating a trust, or what's the purpose? Why do I need to create a trust? And I say to them, no. There must be some misconfusion here. You're not creating a trust. You're reorganizing an existing trust. Your legal name trust was already created on your birth date. Okay? So we're not creating a brand new trust. Right? Whatever your name is, John Doe, you know, Cindy Smith, whatever your name is that you were born with a birth certificate, that trust already exists. Right? That's undoubtable. You've been using it your whole life. The government's been in control of it your whole life. So what we're doing, and if you got a name change, it's still the same trust. Nothing has changed other than the name that you want it to be called got approved by the trustees. And then you assumed using that as well. So 5 words, 6 words or less, you're reorganizing your legal name trust. Reorganizing, is that 1 word or 2 words? Let's say it's 1 word. Reorganizing my, because you would say, you know, if you're saying this out loud, you would say my. Reorganizing my legal name trust. 5 words. 5 words or less. So if I ask you, hey, pop quiz, do you even understand the process that you're doing or that you're about to do, or that you're calling and saying, I want to sign up and I want to do this SPC process, I may ask some of you, in 5 words, what are you doing? And you shall punctually say, reorganizing my legal name trust. That's it simplistically. And there's lots of other things that are done as layers on top of that that are more advanced, but that's simple. If you don't know the foundation, if you don't know the simplicity of what you're doing, let's just focus on getting you to understand what it is that you're doing, because that makes it not overwhelming for you. That makes it, you're clear, you're confident in moving forward, you're not hesitate, to get over any sort of hesitation. And I want you to understand what you're doing, and you want you to understand what you're doing probably more than I want you to understand what you're doing. But I don't know, I care a lot about people understanding what they're doing. Maybe I care more than some people, I don't know. But that's what we're doing. Now let me read this letter. One of the letters that we send in the process after we've reorganized the trust and filed certain public notices and so on and so forth, or recorded certain public notices, there's something called a notification of record that we send to the birth state and the state that you live at now that probably has a lot of dealings with you, a lot of trusteeship, a lot of administration, a lot of control over your legal name trust has been, you've got property registered through it, you've got bank accounts set up there, you've got a mailing address set up there. Whatever the state that you live at now, you've got employment contracts there. Whatever situation whatever state that you're doing the most activity in, or that you are domiciled in, or that you deal with, that state plus your birth state need to be notified. Why does your birth state need to be notified? Because they have the original, that's where this was all started. your legal name trust was created there. So you got to send the state that you are dealing with now, that you live at, excuse me, and the birth state, and Washington, D.C., and the entire auditors. The IRS are the auditors and tax collector, everything that's going on between transferring property and all these different things. So you need to notify them as well. So you're notifying 4 entities: the birth state, the state you're living at now. Now, if they're the same, then that's it. Then you don't need to notify both of them. Okay. The Washington, D.C., for the U.S. corporation to give them notice, and the IRS, okay, who are the financial accountants and auditors of everything and keeping track of everything and who owns what and blah, blah, blah. So when you reorganize your trust, don't you think it would be a good idea to tell them to put them on notice so that they can adjust their accounting, tax you or your trust differently, send, notices differently, blah, 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 right? So these are the 4 main departments that you need to notify. And this is a letter that we send out to notify them kind of after the majority of your process is done. And once you have reorganized your trust, taken control, after you're a bona fide trustee over your trust and secured party. See, secured parties is just another audio. It's another term. It means something different than, you're a trustee. And there's another layer of what we're doing on there. It has to do with having a security agreement and putting a secured lien hold interest over all of the trust property that is liened by the living man, whatever name you want to call yourself in private. Okay, again, the honey, the sweetheart, the whatever that doesn't own anything and doesn't, have any titles in its name or whatever, the private name that you say to yourself in your private home, but once you leave the house and you buy things or do banking or whatever, it never shows up. Okay, that private name, that private living man that never gets into any contracts, that name, well, it can get into contracts, but it usually gets into no contracts, especially with the United States corporation or the state corporation or any sort of business or corporate stuff. That private name, the living man, the living man or woman has a lien hold interest over all of the all capital letters trust names, property, past, present, future, forever. Okay, that's in the security agreement, and that's posted on a UCC1, where you post liens, which are consensual contracts that are signed by both parties. A lien is a consensual contract signed by both parties. So you, the living man, is signing a contract with your all capital letters trust. So you're kind of signing it with yourself, but you, the living man, is signing a contract with your all capital letters trust, and you're putting a lien, 100 million, a billion, infinite, whatever you want to put. Although you can't really put infinite, you have to put some amount. So 100 million, whatever. So you put that lien over that, and that's kind of a different thing that's going on here. The first thing I really want to get into your head, though, and the purpose of this audio is to cover that you're reorganizing your legal name trust. Boom, that's it. Let that sit, understand what that is, read the documents 10 times and understand that that's what you're doing in the first phase of the process. After that, later, there's a security agreement, there's a lien, there's UCCs, there's lots of other things that you're doing. You're also setting up a fiduciary contract with the Secretary of Treasury that allows you to discharge certain debts. That's the purpose of another audio. We're not even there yet in most people's understanding. I'm trying to just get people to understand the 5 words. You're reorganizing your legal name trust. That's it. So let me read to you this document that solidifies, reinforces that concept. Later on, after we reorganize our legal name trust and we become a registered secured party creditor over that trust, recorded on a UCC, done a bunch of things, done the contract with fiduciary contract with the Secretary of Treasury in Puerto Rico, who is administering the accounts for the United States corporation. All these different things. After that, we do something called a notification of record, and this really drill home the bottom line of what this whole process, the foundation, the most important element, the first component of this whole process, which is reorganizing your legal name trust. So here we go, notification of record. So you're sending it to, where are you sending it to? There's 4 places: birth state, state you live at now or have any significant financial dealings with in the last couple of years or so, Washington, D.C., and the IRS, and you're sending them a notification of record. So 2 would be, you're doing 4 letters, so each one is to Secretary of State, your birth state, the other one is to Secretary of State, the state you live at now, the other one is to IRS, the other one is to Washington, D.C. From you, regarding accounts or trusts under account or sub-account number, your social security number, and your birth certificate numbers. Okay, that's the title. You're sending them a notice in regards to any accounts or trusts under the account or sub-account numbers, birth certificate, and social security numbers. Does that make sense? And what you're saying is, Dear Secretary of State Record Keeper, or Dear the IRS, right? Or Dear Washington, D.C., who we address. Or there's certain states that, for example, Hawaii or Guam or Puerto Rico, some of these places don't have Secretary of States. They have lieutenant governors who fulfill the same capacity. So you might say, if you were sending this to Hawaii because you live there now or were born there, you would say, Dear Lieutenant, or Dear, I guess you could say Dear Secretary of State Record Keeper, but you would address it to the Lieutenant Governor. And there's other states that are called Secretary of the Commonwealth. Pennsylvania is a Commonwealth state, so they're called Secretary of the Commonwealth. So you might address it, Dear Secretary of the Commonwealth Record Keeper. But for most people, you're going to address that, Dear Secretary of State Record Keeper. So here's the meat of the letter. Until recently, I was unaware that there were affairs being managed on my behalf without my knowledge or consent that have been left improperly tended to with atrocious results. So basically, you're telling them, hey, I kind of realized that I have been a beneficiary and you guys have been regulating, controlling, and profiting off of this trust, supposedly for my benefit, but without my knowledge or consent. I didn't know that this was a trust being managed on my behalf, right? You didn't know when it was set up because you were a baby, right? And you didn't know when you were 1 year old, 2 years old, 5 years old, 10 years old. You waited until now. You're 50-something years old. You're 40, 30-something years old, most of you people, right? And now you're finally realizing, wow, my whole life there's been a trust being managed on my behalf, right? So you have to tell them that recently you became aware that this was going on, without your knowledge and without your consent. Until recently, I was unaware that there were affairs being managed on my behalf without my knowledge or consent that have been left improperly tended with atrocious results. So what does that mean? It means that the people that are running it are, you're claiming, improper, or it's being improper tended to. Now it has come to my attention that, and then there's 6 bullet points. Matters are not being handled equitably. What does equitable mean? Fairly. Number 2, matters are not being handled with efficiency. Number 3, in many respects, matters are not being taken care of at all. Number 4, usurpation of funds is occurring. Number 5, there is rampant fraud and deceit. Number 6, position of trustee has been left vacant or properly attenuated. Position of trustee has been left vacant or properly attenuated. So definition of attenuated is weakened in force or effect, unnaturally thin. Look at some other definitions. Reduced in value or force. Reduced in force or value or amount or degree, to weaken or to diminish. Okay, so you're saying that the position of trustee has been left vacant. Definition of vacant is not filled, having or showing no intelligence or interest. Okay, so you're also stating that there's fraud. So in order to remove a trustee, you must accuse it of him or her of committing fraud. Okay, I had somebody say, oh, well, I don't want to accuse the state of committing fraud, blah, blah, blah. You can't just say, oh, I don't like what's going on, and therefore I would like to remove you as a trustee and put me in place as a trustee. You can't just do that, right? The shareholders of a corporation can't just say, oh, we don't like this, it needs to be done properly. The beneficiaries of a trust don't have any say unless there's fraud. So you must say that. So you can't water down and not say that there's fraud going on, okay? So we continue with this. I have waived beneficial position and interest to take a position of trustee to manage the affairs of the trust, your all capital letters legal name, copyright, and full control forth hence as indicated and identified by the account numbers above. Because there's many people with different names. I mean, there's many people with the same name, right? That might, when Secretary of State of California types in, they get this letter and they type your name in, there's many people with the same name. So you have to use the birth certificate numbers and social security numbers or number. I have waived beneficial position. So when you send this notice out, you have to have already done this. You can't send this letter out prematurely and say you've done something that you haven't done. So that's the point of the original trustee or the original trust meeting in the beginning, which is the first step before you even register, do a security agreement and UCC1 and all the different things. Before you do any of that, setting up a fiduciary contract with the Secretary of Treasury of Puerto Rico, before you do any of that stuff, you have to reorganize your trust. How do you reorganize your trust? You call a meeting to order. You have a meeting. You make an intention. How did they create the trust of the original Constitution of the United States of America, or the original Articles of Confederation, so that all the individual states can be their own nations, but have a pact and a contract to support each other and to give the people freedom and sovereignty? How did they do that? They just had a meeting. How do you do anything? You have a meeting. The most important thing to create anything, the first starting point to create and form a corporation, to form a country, to form a trust, to make a purchase, to execute a sale, whatever, right? You have a meeting. Well, first you have an idea, right? And you decide that you want to do something, and then you call a meeting to order, right? So they called the meeting to order. They called people down, and they created all the different states, and they signed these articles of Confederation. Later on, they did the Constitution. Okay, they had another meeting. They had another trust meeting. They said, oh, we have to do something extra now, and they formed the Constitution. So you are basically, everything that you do, pretend you're mimicking creating your own country. You're mimicking creating your own government, because literally that's what you're doing. Your own trust is your own country. It is your own government. It's a miniature nation, okay? And who is governed by your miniature nation? You, your family, and your kids. Or you might have other parties that are involved too as well. You might have other people that are beneficiaries of it that are, in your nation. You're forming your own country and nation. It's very, very, very powerful stuff. But I hope that you see that that's what you're doing, because this is private law. This is common law. This is private law. Your trust here, there's no regulation. There's no asking for permission. There's no... Its existence is not contingent upon the government recognizing its existence. Its existence is self-evident. Self-evident, didn't the founding fathers say, we find these truths to be self-evident? Okay? Now, whenever there's a country that's formed and they say, hey, we find these truths self-evident, we're free and we're breaking away from the king and finding our own country, and this is our document. That's like their trust declaration document. The Declaration of Trust is the first document, and the Articles and later the Constitution were trust declarations. The Declaration of Independence really was the first one, right? And then they said, okay, now we need to organize a trust meeting and really formalize all the terms and all the conditions, and then they continued on that. So they had trust meetings to form their own country. However, just because you do this, again, it doesn't mean that the king is going to immediately recognize your sovereignty. Didn't they say, no, we don't recognize your independence. We're going to send our troops over to fight and shoot at you and kill you and try to get you to surrender and sign a treaty that you're not sovereign. So don't think that the secured party creditor process or this reorganizing your own trust process makes you invincible. I still just recommend to people to blend in and lay low and don't be noticed and just skate through life without winding up in court, hopefully. But if you're in a situation or you expect a situation or you want the protections just to feel protected, if you get into a situation where someone tries to drag you into court, civil, criminal, whatever, you have all this foundation laid, and then you can flex the muscle. And then you can win, and there's case law that absolutely supports that you can win your position that you are sovereign and that you are your own, your trust is under your own jurisdiction and it cannot be regulated and so forth by anyone else that you did not grant or cede authority to. Okay? So your declaration of trust is your own founding of your own nation, your own country, basically. And you're making yourself like the president of it. There you go. And you're creating the you're in the Declaration of Trust, you're creating all the terms and conditions of what you can do at a later date. Just like how the Constitution says, this is what the government can do at a later date, and this is what they can't do at a later date. They can always go and have meetings in Congress and put they can vote on whatever that they want, but they can't infringe upon our right to bear arms and our right to free speech and our right to due process and blah, 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 blah. So all those terms were concrete. The Declaration of Trust is a concrete document. You can't do anything contrary to the Declaration of Trust, just like you can't do anything contrary to the Constitution. They can try to, but it can get overturned later on if someone causes a big enough of a stink about it. One of the beneficiaries of the Constitution, one of we the people, someone causes a big enough of a stink about it and says, no, I don't want my right to firearms to be, I'm gonna fight that in the courts. And it goes all the way through the courts, ultimately winds up at the Supreme Court, and the Supreme Court is the checks and balances. The Supreme Court says, yeah, that violates the Constitution. So they will say that that's null and void. And it never was valid. Any attempt by the government to infringe upon a right to bear arms or due process or free speech or freedom of religion is null and void ab initio from the beginning. The Supreme Court will determine that at some point years later. Okay? Why? Because the trust known as the United States of America cannot violate its original founding documents. Okay, so everyone talks about, oh, that's unconstitutional because it's not in the Declaration of Trust. So you cannot, you can amend the Declaration of Trust, but how do you know how to amend the Declaration of Trust? Whatever it says in the Declaration of Trust. So whatever it says in the Constitution, here's the ways that we can amend the Constitution. It says it in there. And then you can follow what it says of how to amend it. You can't just make up your own ways and theories about what constitutes having the authority to amend it. So it's the same thing with your Declaration of Trust. Whatever's in there about how you can amend it, there you go. As a in our private Declaration of Trust for your legal name, our general standard run-of-the-mill cut and paste trust language is that the Board of Trustees can amend the Declaration of Trust at its will upon a consensus by the Board of Trustees. Simple as that. There's no reason to make it more complicated than that. Okay? Or you can edit it and say whatever you want, or add whatever words or commas or periods for whatever clarity that you want, or whatever modification that you want based on what you want to do. Okay? So now the cool thing about this is when you set up your own, you're not setting up a brand new trust. When you reorganize your existing trust, you're following the motions of what documents you need and what thing you need to have an idea. Then you make a decision that you want to have you want to set up the trust. Then you call to you have a meeting and you invite people. Then you call the meeting to order and you go through everything. So the same way that you're going through all that and all the documents that are needed, you're learning how to set up a trust brand new. So after you were done with the secured party whole process, and you process it and you read it a few times and you take a breath and it doesn't become so overwhelming to you and you get it, you can at a later time set up as many trusts as you want. You just been through the whole process. You know what needs to be done. Right? Decide who you want to be on your trust, the name that you want to call your trust, and just go back to these documents and do the same motions again. Edit and delete the name, the legal name, John Doe, from the top of the header of all the documents, or in various places inside the documents, and put the name of whatever trust you want, whatever name you want. So let's say that you wanted to set up after you're done with this whole process, let's say you wanted to set up another trust and you wanted to call it, Sunshine World Trust. For some reason I always use that generic example. But let's say that you wanted to set up a trust called Sunshine World Trust. Why do you want to set up Sunshine World Trust? I don't know. I mean, you already have a trust here, but let's say that you wanted to open up a bank account and have someone pay you and write the checks or the money orders or have on their credit card statements it come up Sunshine World Trust as opposed to coming up your legal birth certificate name. I completely understand that. So this is one of the number one reasons why maybe later on when you're done with the foundation and you're done with your sovereignty and you're done with your learning about trusts, getting involved, seeing and experiencing the motions of setting up a brand new trust. Again, your legal name trust is not setting up a brand new trust, it's reorganizing your existing one, but the same motions that you do are required, coincidentally, for setting up any other brand new trusts. Okay? So if you wanted to set up a brand new trust, pick the name, pick who you want to be the grantor, trustees, and beneficiaries, and there you go. The same thing. Have a meeting, pick the people, declaration of trust, meeting minutes, and that's it. You don't do UCCs, you don't send things to IRS, you don't send things to Secretary of Treasury of Puerto Rico. You don't, it's not, you're not doing the full secured party creditor process and all its motions. You're just doing the trust motions and documents. Okay, and yeah, you're getting an EIN number through the IRS if you want to bank in the United States, but you don't need to. If you want to just accept gold and silver privately, or you want to bank in Europe, or you want to bank in South America, or you want to do Bitcoin, or you want to do something else, then you don't need an EIN number from the IRS. Okay? It's only if you want to do banking in the United States, you're going to need an EIN number. So, again, the legal name trust was created on your birth date. But if you want to set up other trusts, mostly just for the name situation, there might be other reasons as well, but that's not the topic of this conversation. Let's just get back to, the main topic, okay? So in this letter that you're sending to the Secretary of State and elsewhere, you're telling them, until recently I was unaware that there were affairs being managed on my behalf without my knowledge or consent that had been left improperly tended with atrocious results. It has come to my attention that there's fraud, position of trustees left vacant or properly attenuated, blah, blah, blah. And then you say, please return all, oh, no, I skipped a sentence. I have waived beneficial position and interest to take a position of trustee to manage the affairs of the trust, whatever your legal name is, John Doe Trust, or just John Doe, all capital letters. I wouldn't put the word trust there. I would just put John Doe, all capital letters. And I waive beneficial position and interest to take a position of trustee to manage the affairs of the trust, your legal name in caps, and full control forth hence as indicated and identified by the account numbers above. Please return all information to the address above if you have any on hand or is in your care to the trustee. Because earlier in the document you're telling them that you're the trustee. All others are now barred from handling affairs in regards to your legal name in all caps. All contracts that are in existence for the trust are to be returned to the trustee within 30 days for management or shall be considered vitiated, nunc pro tunc, void from inception by the trust forth hence. Your prompt cooperation is generally appreciated. So, if you Google vitiated, it says to spoil or impair the quality or efficiency of, or to destroy or impair the legal validity of. So you're nullifying or canceling the legal validity. All contracts that are in existence for the trust are to be returned to the trustee within 30 days for management or shall be considered vitiated or nullified or canceled. Nunc pro tunc, which is Latin for now for then, void from inception. So from day one, from your birth date, it's all canceled like it was never there to begin with. That's what that means. Your prompt cooperation is greatly appreciated. And then the last paragraph, furthermore, this and all pertinent documentation has already been filed as a public record under necessity in the commercial registry of the state of whatever state you did your UCC filing in, under filing number, whatever your UCC filing number is. This is notice and acceptance via your receipt of this mailing. If you feel this notice is in any way in error or disagree with the change in position, the trustee beneficiary swap, if you feel this notice is in any way in error or you disagree with the change in position, please feel free to rebut this notice with your concerns within 30 days, or it will stand as fact prima facie. So rebut is to claim or prove that some other accusation is false, okay, or to repel something. So if they don't rebut what you stated in here, for the time being, it'll be the legal understanding of the parties that it's true and it's correct, right? That's called prima facie, based on the first impression, accepted as correct until proved otherwise. Okay, so it's a legal concept. Accepted as correct until proven otherwise. So if you feel this notice is in any way in error or disagree with the change in position, please feel free to rebut this notice with your concerns within 30 days, or it will stand as fact until proven otherwise. Notice to agent is notice to principal. Notice to principal is notice to agent. That means that the Secretary of State of the state, or whether it was you're sending this to the IRS or whatever, that's the principal. That's the one that you're contracting to, the one that you're trying to give the notice to, and make sure that they comply with it, they acknowledge it, and they have a legal duty to respond, or they accept it. The principal is the entity that you're noticing. The agent is just the individual employee who opens up the letter. Okay? So when you say notice to agent, notice to the employee, is the same thing as notice to the principal, the entire Secretary of State of California, and you're saying that the notice to the entire Secretary of State of California is also notice to the agent, that just covers yourself and says that, all right, you can't say, they can't come back later and say, well, we just had an employee open up the letter and the Secretary of State of California never really knew, we never really had the ability to really, understand this or read this. It was never given to us. Hey, I notified one of your employees. That's your fucking problem. That's it. Okay, so that's what that does. It covers your legal basis. And then it says trustee and secured party, your name, without prejudice and without recourse, without prejudicing your rights, your signature, your date, and then you also say that you're an authorized representative of your all capital letters name. So that's one of the main. It's a simple letter. It fits on one page. You must send it with something like a certified mail tracking and keep records of those. And we post the certified mail labels onto your UCC ones after these are mailed too. We do a very comprehensive, involved, UCC posting process. There might be multiple UCC filings that are done. The state that we do it in is very particular based on you. It's not just like, we had people shopping around. There's other SPC things people found. They say you have to file all your UCCs in the state of Washington, and all these different theories that people have. We personalize what is the best place for you to do UCC filing based on a lot of different factors. So when we have you fill out the information, we give a recommendation of where's going to be the best place to do it, and then we look through all your application and your data sheet, and we hand select the UCC region based on our experience, based on my mentors, based on the successes that people have with this. Is very specific. We can't just say everybody file in the state of Washington or whatever these other people are saying. So, but you're filing that, and we're filing dozens of pages on there. There are dozens of pages that are posted on there. A lot of these affidavits and some of these trust documents and these certified mail receipts and different things like this showing that you've given notice of this to Secretary of State and to the IRS and to Washington, D.C. A lot of these things are posted on your UCC. So, again, a lot of people that come to us who have done this in the past, they were taught, you file UCC and it's one page or it's 2 pages. The average number of pages, sometimes it's a page or 2 less or a page or 2 more. We got 32, 33 pages that need to be posted on your UCC, whether it's on the UCC 1 or an amendment to it, which is a UCC 3, or whatever, other UCC 3s or amendments. You can always keep adding new information or editing mistakes that you've made or deleting entire sections on your UCC posting by doing a UCC 3. So you can do as many UCC 3s as you like for the rest of your life to fix, change, edit, or so on and so forth. But there's a lot of stuff that we need to post on there because it's all tying everything together and creating that prima facie case of who you are, what you've done, and so on and so forth. Again, based on your first impression, accepted as correct until proven otherwise. So again, don't think that they're absolutely going to just lie down and let you do anything and go off there. Just because you're an you become a secured party and you do this whole process. Doesn't mean that you can just walk past police and just smoke marijuana in their face and blow it in their face and be stupid and know that he's going to jump and pounce on you and arrest you and charge you with unlawful possession of marijuana, right? I know it's legal in a lot of states, but obviously you wouldn't blow it in his face. But I'm trying to make a point. Don't go out there and do stupid things. Don't go out there and be overconfident that, oh, if you get stopped and frisked or a normal person would get arrested, you're not going to get arrested. That has been reported to be the case in many instances, but it's not 100%. And I would just expect that, just like anyone else, you would be arrested for the same stuff. It's possible they punch you in a computer, and if it's low-level stuff, and especially if you start to assert your rights, that they will let you go. But I've heard cases where they started asserting, I conditionally accept this and that, and I'm secured party, you don't have jurisdiction over me, blah, blah, blah. And I've seen people be let go, but then 10 months later, they formally charged them and issued an arrest warrant and charged them and brought them in. Okay, so it doesn't make you invincible, but it makes you so that if you develop a situation, civil or criminal, you can handle it, and all your property is your property. If it's a civil, they can't take your money. If you defend yourself and utilize this and utilize your filings and showing all those pages that were posted on the UCC and that you sent these notices to the Secretary of State and you have the security agreement and you've done all these things and you have reorganized and you're the trustee of your legal name trust, if you show all these things, you can defend a civil action and prevent a lawsuit. No matter how high the amount of the money is, you can prevent a lawsuit because this protects the assets of your trust, because you have a security agreement in place for $100 million that is nunc pro tunc to your birth date, so or to your birthday or your 18th birthday, because you can't contract before your 18th birthday anyway. So any contracts before then are null and void anyway. So any contracts that are not in your best interest are null and void anyway. So you're nunc pro tuncing back to your 18th birthday, right? That you, the living man in private, has the first and only superior lien hold interest over all capital letters property anyway. So that protects you from civil lawsuits as well. But the civil and the criminal are all tied together, because a criminal is just an escalated civil action where they're repossessing the automobile when you don't make your car payment, and the property, instead of the automobile, the property is actually your body. And so that's what they're doing there. It's a security agreement that the government has over people and over people's bodies that was created with the birth certificate. So that's the reason why we are taking control and basically canceling all those contracts, the birth certificate contract that gave them authority over your body and your property and your life and your future and your offspring, that contract, the Social Security contract, all those contracts are they're null and void. Those documents are still there, registered in the government system, but you're putting modifications and amendments over to them with these public notices saying what they are and what they're not. Okay, and unless rebutted and proven otherwise, this is what they are. And there are maxims of law, and there are, if something is fraud, then you can step in and do certain things. So there are maxims of law and court cases and definitions and equity and common law and all these things that put together, whereas you can stop people from assuming that they have control over your trust and from them assuming that they have control to repossess your body or take your property or tax you for, certain things. So that's, I guess we'll do another audio soon on what, people can do if they get into trouble, whether it's a civil or criminal situation. But obviously you can contact us at any time. You can call us and you can call our number, and you can, we're here one-on-one to answer questions in private confidential setting to assist people and bring people. We're never going to be able to do all the audio recordings to get to the point where everyone is self-sufficient to do everything, themselves. 110% on every situation, every question answered, you can always call us and ask us for help. We encourage it, okay? And don't feel shy about I don't want to call you, let me send you an email. We don't answer emails. we get hundreds of emails a day. So if you're a client, we have client email addresses that we check and respond to, virtually every single day. But we have a main email. You might be getting getting this audio recording on our main email address, which is contact@understandcontractlawandun.com. And there are months in a row where we never check those emails. And if we do, we may not answer all of them. We may just say, oh, people are asking a lot of questions about this. It's a good idea to do an audio recording about this at some point in the future. If it's something that you personally need help with, question answered, you have a situation, give us a call. Don't be shy. Don't send me an email back because I'm not checking those emails. There's hundreds of emails. If you care and you're serious and you really want to fix the situation, give us a call. The phone number is 505-340-3632. Okay? Make sure that you've looked at some of the information on the site so you have clear, concise, and intelligent questions. And we spend hundreds of hours putting the website together. You don't have to look at every single section and dig into all the past archives, but look at the main stuff. Watch the main webinar replay on the homepage. Look at the different products under the products and see what we offer. And then make a list of clear and concise questions and call us and ask us, do you guys do this? What do you guys charge for this? Can you guys help this? Have you ever helped people with this? Do you have any advice or recommendations for this? We don't all 100%, charge everybody just for providing a little bit of guidance and help and answering a few questions here and there. But if you want to hire someone, if you want a lot of personalized help, we're available to it. So give us a call. Let's start the dialogue, start the conversation, and see whether we just put you in the right direction, or whether we give you some things that can help you, or whether we wind up helping you, hands-on, rolling up our sleeves and working together with you. Whatever it is, give us a call, okay? But look at the stuff on the site, particularly look at the webinar replay, understand this information. Obviously, listen to this audio if you've gotten this far. And also please look at www.whatisasecuredparty.com. Okay, www.whatisasecuredparty.com. And I think it's like a 15 page document. It's not a whole website. It's just a PDF document uploaded at that web domain, okay? So that you can just cut through there's no fancy graphics on there. There's no fancy, flashy, anything. I'm a very cut to the chase, show me the meat and potatoes, just show me what works. Show me what works now, show me what not to do, show me what to do, and show me how to get there with ease and grace, with as least problems as possible, and just tell me what I need to get there. That's where I'm from. That's what I do. That's what I've been, that's the character that I've molded into over the course of my life. That's me. Some people like it, some people don't like it. Okay? If you're looking for someone to cry on your shoulder for 3 hours and give you emotional support, that's not me. I don't have the capacity to do that to, people I meet over the internet. I have a few friends in my life that I can squeeze a little bit of time to do things like that, but and loved ones and family, but when it's needed. But I'm a very cut to the chase, just show me what to do type of guy. So if you like that attitude, we might be able to work together very well, okay? So, but when you call, make sure you have a pen and paper. Make sure, you've got clear and concise questions. I don't want to hear a whole rambling, and it's not just always me that's going to answer the telephone. I have supportive, friendly, intelligent, well-trained team members that are answering all the plethora of phone calls that we get. So please talk with them. Don't call and demand that you talk with Tyler, because I don't do most of the phone calls. But when you speak with one of us, make sure that you have clear and concise questions, intelligently formulated. They're short, and you can just ask what you want to know. Okay? Sometimes, we can say, oh, okay, tell us more about that. Tell us what happened. And you can tell us the story of what happened within reason, not going on for 2 hours, only covering the important facts, So we encourage that. Give us a call. If it's going to be a long call, we really encourage to do a paid coaching call consultation. If you're not sure yet, you can just give us a call. You don't need to go online and pay if you are trying to call and ask us, or you think it's going to be a short 5 or 10 minute conversation. But if it's going to be, if we know, or if the call starts to get into and it gets longer and longer and very long, then please respect our time. Support our organization. We're expanding and growing more staff every month to handle and be able to help more amounts of people. We all do this full time, so we get full time. We all do this full time, so we need to live and pay our bills. So please consider paying for a consultation, especially if you have an important issue, you really need to go into a lot of detail, especially if you have documents that you want us to review ahead of time, things like that. But you can certainly call first for the initial 5 or 10 minutes, no charge, no obligation, and you can call and just to double check about anything you want to double check about. Oh, can you guys help with this? Should I bother paying for a consultation? That's perfectly fine. Should I bother going online? It's a little expensive. It's $100 or for a half hour, or $200 for an hour. That's fine. You can call and check. I'm trying to see if it's worth it for me to pay for a consultation. Do you guys help with A, B, and C? I studied things on your website. I listened to your audios. I read the whatisasecuredparty.com thing, and I don't have the answer to this. Very likely that there's going to be a ton of things that are not answered or explained, but people have a lot of, there's an infinite number of questions that can be formulated. So give us a call when you've reviewed that information. Whatisasecuredparty.com, the webinar replay, the information on here. Give us a call. Again, the phone number is 505-340-3632. Now, when you call, and we're always changing this and we're always, changing things around to try to make our ability to help people more efficient, help more people in less time, spend less time repeating ourselves on the phone, saying the same things to lots of people that can be, posted on a recording. So when you call, depending on what time and if this changes going on into the next year, there may be a recording, okay? There may be an English lady saying, "Greetings, thank you for calling, understand contract law, and you win.com, yada, yada, yada." Okay, please, if it's your first time calling especially, listen to her and respect her and jot a couple of notes down. The automated recording may go on for a minute or two or longer when it's your first time calling, and it's going to give you certain extension numbers, and please write down those extension numbers, and then when you call back later you can skip the recording and you can just hit whatever extension number of the department that you want to reach. But when you call for the first time or the first couple of times, please listen to the recording, and as things go on you can certainly just hit the number on there and punch in and skip and go right to either the same individual that you were speaking with on the prior phone call or the same department, right? We have a sales / answering people's questions / consulting department. And then we have a department for people who have already officially paid for consultations, and it's a separate department, it's a separate extension number. Then we have a separate extension number for people dealing with foreclosures. Then we have a separate extension number for, I think, the line of credit and credit repair. We have separate extension numbers for other things. And we have also private extension numbers that you don't find out about unless we tell you, so that we can keep certain people in the background, quietly, efficiently, working on particular projects, on particular people's court cases, or helping them to eliminate certain debts or helping them in certain situations. People need to be quiet without the phone ringing all the time. Certain people, okay? So we have other people that will just answer the phone and return calls all day long. But we have other departments of people who get a minimal amount of calls, and almost nobody knows their extension numbers unless they're their particular client. So I hope that makes sense to you. I hope that the people that are business savvy people are saying, "Oh, okay, this is really well, put together. He's trying to be very efficient and help the most amount of people. I like that. I respect that. I'm grateful for that. I'm glad I found understandcontractlawandyouwin.com, because we are really trying our best, and I love feedback, but we are always trying our best. We're always trying to improve, and we're always trying to provide people with the best product, the best service, the most effective product, the most effective service, and in the most efficient manner that helps the most amount of people. And that's basically it. So listen to all the other recordings that I send out as well over the course of time. You don't have to wait to call us to have listened. You don't have to listen to 20, the next 15 audio recordings that I send out in order to call us. But if you're not sure what your questions are, then maybe listen to a few other recordings before and make a list and try to narrow down what your questions are before you do call us. But obviously, if you have a pressing emergency situation, court date a certain time, this type of situation, you're in major trouble, just call us right away. Okay? Once again, 505-340-3632. We look forward to working with you, and I'll be talking to you soon.